I must begin by making a special tribute to our president, the Honourable Justice Madame Lecoeur, who was instrumental in the organization and development of this webinar and should have been its chair. Regretfully, he had vocational commitments to honor and could not join us at this time. So it's my honor to stand in for him and chair the session. The session now has 63 registered attendees, and I would like to thank you all for joining us today. Among these, we have many distinguished justices, both as panelists and as attendees from all around the Commonwealth. And I wish to welcome you all and hope that you have a satisfactory session with us. Please note that there's a question and answer box, which will remain open during the session. If at any point you have any questions, we will address these questions at the end during a moderated Q&A session. You're also free to use the chat function to introduce yourselves and connect with fellow members of the judiciary. Now, an alarming fact: 1 in every 150 people in the Commonwealth is living in modern slavery. This translates to about 16 million out of the worldwide figure of 40 million people in modern slavery. This statistic is part of the wide range of information and commentary that can be found in the 2020 publication entitled Eradicating Modern Slavery by the Commonwealth Human Rights Initiative and Walk Free. Walk Free is an initiative of the Moderator Foundation. Importantly, it provides a sobering assessment of Commonwealth government's progress on achieving the Sustainable Development Goal Target 8.7 to take immediate and effective measures to end modern slavery by 2030. In a foreword to the report, Grace Forrest of Walk Free considers that the effects of British colonialism are still being felt today. And I quote her, Centuries on from the abolition of slavery, racism and inequality are still roadblocks to sustainable development, unquote. Alarmingly, slavery exists in each of the 54 countries that make up the Commonwealth. And the COVID-19 pandemic has increased vulnerability to modern slavery around the world. The disturbing and current impact of all of this was brought close to home by our President, Justice Madame Lecoeur, in a recent article which commenced, "Shocking news has come from a child rights NGO. An estimated 3 million children have been rescued in India after being trafficked for labor between April 2020 and June 2021. Such is the horrifying magnitude of child trafficking." The relevance of this to judicial educators in the Commonwealth is highlighted in the assessment in the report to which I referred. Lack of legislation across most Commonwealth countries undermines efforts to deter and combat perpetrators of modern slavery. The effectiveness of criminal justice systems in this area continues to be compromised by weak implementation, even where relevant legislation exists. Resources are limited, and training for criminal justice officials remains patchy, with only 12 countries mandating systematic training. This webinar is intended to raise awareness of the need for judicial education on this social scourge by discussing the contemporary forms of slavery, the importance of the issue for judges, looking at good practice by governments in addressing issues of judicial education programs and reach, and to seek commitments for the next steps for our judicial educational programs. Now, please allow me to introduce our first speaker, Sneh Aurora. Sneh Aurora is director of the London office of the Commonwealth Human Rights Initiative, which is a co-host of this program. The Commonwealth Human Rights Initiative is an independent, non-profit, non-partisan, international non-governmental organization working towards the practical realization of human rights across the Commonwealth, as well as working on issues of access to justice, access to information, and media freedoms. CHRI supports the achievement of Sustainable Development Goal Target 8.7 to eradicate contemporary forms of slavery and human trafficking through research, advocacy, capacity building, and strengthening of networks and coalitions. Sneh is on the management committee of the CHRI founded Commonwealth 8.7 network, an international network of over 60 civil society organizations working towards a shared vision to eradicate contemporary forms of slavery. So, as I call on her, I would ask the question, Sneh, what do we mean by human trafficking and modern slavery? And could you elaborate for us the nature of these issues and the scale of them, so we can understand better why we are discussing this issue today? Please, I give you the floor.
Yeah, thank you, Sir Dennis, for that introduction. CHRI is very pleased to be invited to be part of this seminar, and I thank the CJEI for the invitation to address all of you today. In response to your question, Sir Dennis, I'll speak to two topics related to this issue. One is the nature of human trafficking, forced labor, and modern slavery. And the second is the scale of the problem that we are talking about. I'd like to start with a story, if I could. It's an anonymous story that is typical of so many. A woman is escaping domestic violence and meets an older woman who says she can get her employment in a shop. The older woman takes her to a house where she is made to undergo a traditional juju ceremony, believing that her child will die if she breaks the oath. She is then taken to a brothel, raped, and used as a prostitute. She is also forced to take drugs to ensure she has no control over her situation. When police raid the brothel, she is scared to tell them that she has been trafficked out of fear of breaking her oath and therefore fearing for her child. And as a result, she is seen by police as a prostitute working to feed her drug habit. This is an experience that might come to mind when we think about human trafficking. The various incarnations of human trafficking and contemporary forms of slavery, however, continually evolve, as do the complex and nuanced environments in which they exist. But yet, we must understand the particularities of human trafficking, forced labor, and modern slavery in order to determine the appropriate responses to it. Human trafficking is a relatively well-known form of modern slavery that extends beyond trafficking for sexual exploitation to include also trafficking for labor and criminal exploitation, domestic servitude, and instances of forced marriage. Next slide, please. Human trafficking is based on the Palermo Protocol, which sets out the internationally accepted definition of human trafficking. It defines human trafficking as any act of recruitment, transportation, or holding of persons for the purposes of exploitation. And I believe that my colleague Anne will be talking a little bit more about the Palermo Protocol in her talk. Commercial sexual exploitation takes on many forms, but involves any form of exploitation where a person is abused in a sexual manner. These forms of exploitation disproportionately affect women and girls, who make up 99% of victims of forced exploitation sexually and 84% of forced marriage victims. The most prevalent form of modern slavery-related crime is forced labor, which includes any involuntary situations of work where there is a threat of penalty or the denial of a freedom. Domestic work in particular is an industry where those are particularly vulnerable to exploitation by virtue of its private setting and difficult legal protections. Forced labor is often called bonded labor, and it's when a person is forced to work to pay off a debt. Sorry, this is debt bondage. It's often called bonded labor, and it occurs when a person is forced to work to pay off a debt. But most or all of the money they earn goes to paying off the debt. Domestic servitude refers to the labor of an individual in the home of another, where there may be a denial of freedom or other conditions of exploitation. This form of slavery is also disproportionately affects women. And in addition, victims are often sexually exploited when held in domestic servitude. International good practice is increasingly looking to supply chains and the role of businesses in tackling worker exploitation. Supply chains are increasingly global, which makes them more vulnerable to instances of worker exploitation. And some countries are using legislation to put the onus on businesses to clean up and ensure transparent and slave-free supply chains. This transparent supply chain approach is likely to be a key transnational mechanism for future progress in combating exploitive labor situations. Human trafficking, forced labor, and modern slavery also includes the sale and exploitation of children. While these are some of the most common forms of modern slavery-related exploitation, there are also emerging and currently underreported forms of exploitation that include orphanage trafficking. This is an emerging form of child exploitation where children are taken from their families and placed in institutions to attract donations to profit their exploiters. And also what we call virtual trafficking. And this is the use of online platforms by traffickers to solicit and manipulate individuals for the purposes of exploitation. Online exploitation of this kind has thrived recently due to the increased time children are spending unsupervised online during the COVID-19 pandemic. So you'll see that there are a number of terms that you might have heard that we've talked about so far. The term modern slavery is often used as an umbrella term for the range of criminal offenses relating to human trafficking, forced labor, and the holding of a person in slavery or servitude for the purposes of exploitation. The UN defines these heinous crimes under the overarching language of human trafficking, forced labor, and modern slavery, or even the term contemporary forms of slavery is used. While preferred terminology may vary across the globe, we are referring to, generally, situations of intended or actual criminal exploitation that a child is subjected to, or that an adult cannot refuse or leave because of threats, violence, coercion, deception, or abuse of their position of vulnerability. In such cases, there are some key points to note. First, vulnerability is the root cause of exploitation for slavery-related abuse. Second, that all genders, not only women and girls, can be victims of sexual exploitation and other forms of exploitation. Third, that sexual exploitation often takes place alongside other forms of modern slavery-related crimes, such as because the individual is dually vulnerable at this stage. So there may also be domestic servitude or forced labor. And also finally, related to children in particular, where a child has been exploited, it is not legally necessary to prove that they were coerced or forced. By right of age, a child is unable to consent to the work or service undertaken. Now, very briefly, turning to the second point I'd like to address, Sir Dennis, and the second point of your question, why are we talking about these issues today? What is the scale of the problem? As you mentioned earlier, it is estimated that 1 in every 150 people in the Commonwealth is living in modern slavery. That is 15.7 million men, women, and children subject to forced labor, human trafficking, or other exploitative condition. This is 40% of the global figure of 40.3 million people. Other global figures, 1 in every 3 trafficking victims detected is a child. Women and girls account for 71% of victims of modern slavery globally, including 99% of victims of forced sexual exploitation. In July last year, the Commonwealth Human Rights Initiative and Walk Free published a comprehensive report entitled Eradicating Modern Slavery, which assesses Commonwealth government's progress in achieving SDG Target 8.7, the eradication of modern slavery. And Sir Dennis referred to this report in his opening remarks. A considerable amount of data was collected and assessed in the process of developing this report. It was collected and assessed against 116 indicators and then categorized into 5 milestones, which align with areas expected of a government response. These are support available to survivors, for example, any victim assistance programming and any hotlines or training for police or other service providers. The second is strengthening criminal justice systems, including legislation, access to justice. Third, improving coordination and accountability at national and regional levels. Fourth is addressing risk factors, for example, underlying vulnerabilities, protections for women and girls, labor rights. And finally, eradicating exploitation in supply chains. Relating to each milestone, there are some key findings as well as specific recommendations for government action that are contained in this report. In the interest of time, I will not take you through all the details, but I invite you to take a closer look at the report, a link to which will be provided in the chat box. And here are some key findings for the last two milestones addressing risk factors and eradicating exploitation in supply chains. Specifically in regard to the milestone to strengthen criminal justice systems, we found that only 24 Commonwealth countries legally recognize the non-punishment principle. That is, that victims of trafficking should not be persecuted or punished for illegal actions that they might have committed under coercion. And Justice Jamadar will be speaking more on the non-punishment principle in his talk later this afternoon. We found also that 40 Commonwealth countries have legislated for restitution for victims of forced labor, human trafficking, or other forms of modern slavery. However, in practice, victims rarely receive compensation. The report also found that only 12 Commonwealth countries provide visas to trafficking victims, which are not dependent on participation in the court process. So victims are often forced to testify despite concerns of re-traumatization. In our study, we also found some good practices across the regions. Promisingly, human trafficking is criminalized in all Commonwealth countries in Africa, apart from Lesotho. However, despite the existence of relevant laws, there are relatively few convictions for modern slavery in Africa. For example, after passing anti-trafficking legislation in 2005 in Sierra Leone, the country made its first criminal convictions for human trafficking only in 2020, 15 years later. The Caribbean has examples of strong witness protection programs. Witnesses in Trinidad and Tobago are supported through the National Witness Protection Program before, during, and after the court process. Going to Asia, in 2015, over 40% of all migrants in the world originated from Asia, while Asian countries hosted 30 million more international migrants in 2015 than compared to 1995. It's an increase of over 60%. And even where criminal justice mechanisms are available in the Asian region, systemic discrimination may exclude certain groups from accessing them. For example, in Bangladesh, there is evidence that the High Court did not consider trafficking claims filed by the Rohingya. Although European Commonwealth countries have generally strong legal frameworks and relatively high levels of access to justice, across the European region, vulnerable foreign victims of trafficking are detained and deported for offenses committed under coercive circumstances. This includes cannabis production, prostitution, fraud, and begging. And finally, in the Pacific, there is abuse of cultural practices such as informal adoption, payment of bride price, and child marriage under customary law, rendering women and children especially vulnerable in the Pacific region. And only 4 countries in the Pacific region have criminalized forced marriage in line with the international standards. Finally, turning to recent global events, I'd like to highlight that these emerging events have highlighted the need for urgent action, immediate action, and attention to this issue. The Black Lives Matter movement brought into sharp focus the legacy of historical slavery. It underscores the need to address ongoing exploitation in our communities and calls out injustice and entrenched discrimination. And of course, the COVID-19 pandemic, which has impacted every nation, COVID-19 has exposed the weaknesses in systems of protection. It has exacerbated the vulnerability of those most at risk and has driven modern slavery-like practices underground. Consequently, the lives of the most vulnerable have been made more precarious. A final note, judicial response to slavery is as critical as that of others. As human trafficking and modern slavery is multifaceted, addressing the issues will require the collective will and collaboration across the multiplicity of all relevant stakeholders, including the judiciary, legislators and law enforcement agencies, multilateral agencies, the private sector, and non-government organizations, including frontline and service providers, and of course, survivors. I would be happy to respond to any questions that you might have on this. Thank you. Sir Dennis, your microphone.
Thank you. Thank you very much, Sneh. I would like to invite anyone who has questions to put them in the Q&A box so that they can be dealt with a little later in the program. It's now my pleasure to just tell you a little bit of what I learned from this presentation. Modern slavery-related crimes are particularly complex, interconnected, and increasingly prevalent in our societies, increasingly utilizing technology, competitive labor markets, and exploiting globalization for financial gain. As such, prior to legislating against or adjudicating cases of modern slavery, human trafficking, or forced labor, it is critical to fully understand the causes, vulnerabilities, and impact of these atrocities, particularly from the experiences of survivors. Now, I would like to introduce Ms. Anne Fouillard. Anne is a consultant with the Commonwealth Judicial Education Institute, advising the CJEI on human rights issues and issues relating to human trafficking and contemporary forms of slavery. She has over 20 years of experience in research in the public, private, and non-governmental sectors, and has worked extensively internationally and throughout the Commonwealth on sustainable development initiatives. She is well versed in applied and action-based research approaches in a wide range of themes related to international development and environment. In her work, she is consistently engaged with national and international level policy, working in an advisory role within the Canadian government and with organizations and UN agencies such as the World Food Programme, UNDP, UNEP, and the World Bank. Now, Anne, in order to get you going, can I ask you, what are the main international legal frameworks relevant to human trafficking and modern slavery? And what about our various regions? What regional mechanisms exist that will complement the international framework?
Thank you, Sir Dennis, and thank you, Sneh, for your very extensive and broadly defined view of the whole of modern slavery. It's an honor to be speaking to all of you. My goal is basically to speak to the international legal frameworks that provide states with a legal obligation to address this global challenge. I'm going to start with the Sustainable Development Goals because these came out of the original Sustainable Development Goals conference, but at the 2018 Commonwealth Heads of Government meeting communique, the heads of state reaffirmed their commitment to the Sustainable Development Target Goal of 8.7. And let me read it to you. It's as part of members' countries' objective to achieve the SDG 8.7, heads called for effective measures to eradicate forced labor and modern slavery and human trafficking, and secure the prohibition and elimination of the worst forms of child labor in all its forms by 2025, including the lawful recruitment and use of child soldiers. There were also two other SDGs that were also targeted but not included in the communique, and that was target 5.3, which seeks to eliminate child and early and forced marriage, and SDG 16.2, which seeks to end abuse, exploitation, trafficking, and all forms of violence against children. Firstly, I'm going to speak to the Palermo Convention and its protocols, as these actually are the leading protocols that inform current actions in the area of combating modern slavery. These came out of the 2000 Convention Against Transnational Organized Crime. The first one is there to prevent, suppress, and punish trafficking persons, especially women and children. The second is against smuggling of migrants by land, sea, and air. And the third deals with the illicit manufacturing and trafficking in firearms. The first two are more germane to our current discussion. So the purposes of the protocol are threefold: to prevent and combat trafficking in persons, paying particular attention to women and children; to protect and assist the victims of such trafficking with full respect for their human rights; and to promote cooperation among state parties in order to meet these objectives. Protocol 1 provides the internationally accepted definition of human trafficking, which is the recruitment, transportation, transfer, harboring, or receipt of persons by means of the threat or use of force or other forms of coercion, of abduction, of fraud, of deception, of the abuse of power or of a position of vulnerability, or of the giving or receiving of payments or benefits to achieve the consent of a person having control over another person for the purpose of exploitation. It affirms state responsibilities and obligations, such as the vital principle that consent of a victim of trafficking to exploitation is irrelevant to their identification as a victim of trafficking. It also affirms the responsibility of states to provide comprehensive assistance and protection for victims. And it also emphasizes that states should consider measures for allowing foreign trafficking victims to remain temporarily or permanently in the state in which they were trafficked, as victims or persons at risk may be entitled to international refugee protection under the UNHCR Convention for Refugees. And states are also required to provide training for law enforcement officials on preventing trafficking, prosecuting traffickers, and protecting the rights of victims. So why are the protocols so important? Firstly, the United Nations Office on Drugs and Crime is the main legal instrument to fight organized crime, and the protocols are the key international framework for trafficking in persons. Secondly, it overcomes the weaknesses of earlier international instruments. It also, its measures on definitions and specific actions are way more comprehensive. It also recognizes that women and children are disproportionately affected. Actually, they represent 75% of traffic victims. And its efficiency depends on each member's ability to implement the organization framework. Essentially, each state must be an active participant in the Palermo protocols. It also demonstrates the political will to answer a global challenge with a global response. Now I'm going to speak to the broader international conventions and framework and how these historically evolved. This is going to be very quick. The first anti-slavery convention comes back to 1840. And it was organized by the British Foreign Anti-Slavery Society. It actually also gave impetus to the suffragette movement, interestingly. The second is the 1926 convention called the Slavery Convention, which was to suppress trade and slavery. And essentially it was organized by the League of Nations. And as of 2013, 99 countries had signed, accepted, ratified, and succeeded to its participation. Then there were a multiplicity of ILO conventions, which evolved starting with the Forced Labor Convention of 1930, which carried provisions for vital worker protections for just and fair work. The Forced Labor Protocol of 2014, which was an update of that, which essentially ensured that employment contracts should exist, that they must be signed by both parties. Identity documents, including passports, should be accessible to the worker. Recruitment fees for this labor should also be paid by employers, not workers. Debts must not prevent workers from leaving employment, and wages must not be withheld for any reason. The Domestic Workers Convention also re-emphasized the need to basically required a series of measures to improve work for domestic workers. And finally, the Worst Forms of Child Labor Convention, which is an important one as it's enjoying the fastest pace of ratifications in the ILO since 1919. Its call is for immediate action to prohibit and eliminate the worst forms of child abuse. It prohibits perpetrators from using children under the ages of 18 for any form of slavery. And it also assists countries, it provides for assistance for countries in its international program on the elimination of child labor and offers time-bound programs to ensure compliance. Its worst forms of labor, child labor recommendation number 190 also includes basically recommends the type of hazards for inclusion within a country-based definition of worst forms of hazards by children at work. The next one is self-explanatory. It's for the suppression of the traffic of persons and the end of exploitation of prostitution of others. That was an earlier one. And then the International Covenant on Civil Rights, excuse me here, which basically prohibits a number of practices relating to trafficking, including slavery, slave trade, servitude, and forced labor. This is a continuation of the previous slide. The International Covenant on Civil and Political Rights. The Convention on the Elimination of All Forms of Discrimination Against Women, and then the Convention on the Rights of the Child, which essentially protects children from all forms of sexual exploitation and abuse, ensuring measures to prevent children from being sold, abducted, or trafficked. The optional protocol on the sale of children, child prostitution, and child pornography added to that by ensuring that every child has the right to education, to health, and also specifies particular forms of protection, assistance to be made to child victims, to be made available to child victims. The International Convention on the Protection of the Rights of All Migrant Workers and Their Families, known as the Migrant Rights Convention, essentially deems that members and their families shall be free to leave any state, including their state of origin. Their right shall not be subjected to any restrictions except those that are provided by law and are necessary to protect national security, public order, public health, morals, or the rights and freedoms of others. Now, the regional efforts, I've colored the map to show you where they cover. The traffic in minors is reflected in the Organization of American States, which includes basically all of the Americas. The South Asian Association for Regional Cooperation, SARC, convention prevents combating trafficking and women and children for prostitution.
Please permit me to intervene if you don't mind. We are running out of time.
This is my last slide.
Thank you very much.
Okay. The Council of Europe Convention on Action Against Trafficking in Human Beings, and then the ASEAN Convention Against Trafficking on, persons, especially women and children, and then the Arab Charter of Human Rights, also supplemented by the Arab Convention Against Transnational Organized Crime. So I thank you for listening. Ultimately, there's no blueprint for each country. Each nation must find its way. It's important for the judiciary to be aware of what other executive branches have put in place for addressing modern slavery. At the national level, a whole of government approach, a strategy to set out a comprehensive way forward to address human trafficking is needed. And this strategy should enhance, consolidate, and coordinate actions and initiatives to combat human trafficking domestically and internationally through a victim-centered, survivor-informed, and gender-responsive lens. Thank you very much.
Thank you very much, Anne. I must rush to introduce our next speaker, the Honourable Justice Peter Jamadar, who was admitted to the bar of Trinidad and Tobago and was a puisne judge of that court, an appellate judge of that court, and he has become a judge of the Caribbean Court of Justice since July 2019. In 1997, he was awarded a master's degree in divinity. And he has completed the Commonwealth Judicial Education Institute's intensive study program for judicial educators. And he has a certificate in training judicial trainers from the University College of London's Judicial Institute. Justice Jamadar is the Vice President, Programming and Faculty Member of the CJEI. He also works with the United Nations Global Integrity Network and is the current chair of the Caribbean Association of Judicial Officers. And he has authored 2 books and several publications relating to law. Now, Justice Jamadar, to get you started, what are the critical roles of the judiciary in combating trafficking in human beings? And what in particular are some of the key elements that judges should be aware of when dealing with human trafficking cases or other cases where there might be exploitation?
Thank you very much, Sir Dennis, and welcome to everyone. This is such an important session. My responsibility this morning, this afternoon for some of us, this evening for others, is to just look at the critical roles of judicial officers, and judicial officers have a very critical role. I'm from small island of Trinidad in the Caribbean, Western Hemisphere, and we have experienced slavery, and we are the children of both chattel slavery and indentureship, both forms of forced labor, and those legacies have continued to haunt us in this region. As you are seeing on the slides, currently throughout the region, including in Caribbean islands, questions around this arise. I want to start then with 2 very, very short stories. One is a story that most of us may know. It's that historical story that I just referred to. They're both stories of heartbreak. Chattel slavery started in the mid-1660s, went on until 1834 with emancipation. And then from there, demand for labor to the use of indentured labor, mainly Chinese and Indians who came to these regions. Abolished, that is indentureship, in the 1920s and followed shortly by the 1926 International Convention on Slavery. So that's a historical story. It's a story which destroyed families, destroyed people, and has forever resulted in what we now see, for example, in the United States, in the Black Lives Movement, as Sneh reminded us. But let's move to contemporary times. A young woman, MM, brought into the UK from an African country in October 2006, entered into a contract of employment. Between 2006 and 2010, she was made to work long hours, up to 24 hours a day, underfed, hardly paid, not allowed to leave her host premises on her own, had very little contact with her family back in Africa. Any conversations she heard were listened to, even recorded. Fanciful? No, true. The matter reached the Court of Appeal, the courts in the UK, and eventually the Court of Appeal. And I just want to share with you, out of this modern story, something that the judges of the Court of Appeal were prepared to state very clearly. The essence of the concept of slavery is treating someone as belonging to yourself. It is by exercising power over that person as one might over an animal or an object. Where forced or compulsory labor is concerned, it can be direct. It can also be indirect. Constraint can be mental or physical. It can be imposed by force of circumstances. There's a question that was posted in the chat which asks whether or not you can have universal principles in relation to slavery or contemporary forms of slavery. And to what extent should there be regard or respect for what is normative cultural behavior? It's an important question for many of us in the Commonwealth, where these kinds of practices exist even today. As I go along, maybe I hope that some of what I say can help respond to that. So let's move along a little bit because there's not much time and there's some ground to cover. Very, very quickly, what I'm going to try and help us address this morning is how judicial officers play a critical role to look at and explore how trafficking in human beings, forced labor, sexual exploitation, child exploitation, and this is very critical. They are multifaceted and interterritorial crimes and events. How do we adjudicate these cases? How can we if we don't understand the complexity and unique dynamics that exist? To understand and explore the special responsibilities that we as judicial officers have. Why? Because of the power that we exercise in court proceedings, procedurally, as well as substantively and in relation to outcomes. Judicial officers, therefore, have a very key role to play. And that is part of what I want to explore with you all this morning. Moving along then, modern forms of slavery. What is slavery in our times? As judicial officers, how are we going to determine what should inform a contemporary, a current reimagining of the normative legal standards that should be used by us to adjudicate its occurrences? This is an important question. Professor McCrudden tells us, commenting on that case from the United Kingdom that I referenced, and he's a professor of human rights and equality law at Queen's University in Belfast. And I think this is important. The modern view of slavery takes the traditional idea of legal ownership. Let me pause there for a moment. In the 1926 Convention on Slavery, it defined slavery as the exercise of legal ownership over another human. So here's what Professor McCredden is saying. The modern view of slavery takes the traditional idea of legal slavery, as in that 1926 convention, to which over 99 countries have signed on to, and views it as wrong. Why? Because of the deeper meaning that slavery has. That is to say, slavery reduces humans to mere objects and is thus fundamentally inconsistent with their humanity. Pause for a minute. After World War II, 1948, Article 1 of Universal Declaration of Human Rights says, first article, all humans are equal in dignity and right. That's the core. To be human is to be an I am. And to be human is maybe the first right, the right to be. But the right to be has inherent in it the right, not even the right, the reality, the fact of dignity, of worth, of value. And so what Professor McCredden is trying to share with us is this. Notions of legal ownership are maybe too contractual, and I'll try to interrogate that a little later on. What we have to think about is human dignity. And so as judicial officers, that is a seed thought that I want to share with you at this point. How do we proceed then as judicial officers? I want to suggest we think about a right-centric rule of law approach.
Justice Jamadar, would you permit me,
Yes.
please? We are now at 9 o'clock, the time when we promised to end. Now, I would like to ask our attendees to allow us an additional 15 minutes to give Justice Jamadar an opportunity to complete his paper. And so with respect, I request that you allow us the additional 15 minutes to complete the session.
Thank you very much. Thank you very much, Sir Dennis. I assume you're operating on the principle that silence is consent. So since we have enforced a regime where unless you post a comment in the chat, you're silent, I guess you've all consented. I'll go along quickly because I want to be respectful of your time.
I must say, I have actually got some yeses in the chat.
Oh, well, there you go. Thank you very much. Those who have said yes, who have given their consent. And that's something that I hope I can have the time to touch on as we go along. So, all right, quickly. How do we approach this as judicial officers? I'm suggesting we think about a right-centric rule of law approach. Now, that's built on 4 foundations: sovereignty, supremacy, rule of law and human rights, and judges as guardians of constitutional values. Basically, the principle of supremacy is in post-colonial independent Commonwealth states, most of which have written constitutions. Certainly in the Caribbean, the constitution is declared as supreme. It's a little different from the UK, where the traditional principle is parliamentary sovereignty. That principle of supremacy says that any law or practice that is inconsistent with constitutional values is actually void. Now, when we look at, for example, preambular clauses which declare intent, it's very clear, and the jurisprudence, certainly in the Caribbean and of the court to which I belong, the CCJ, has developed this robustly. The rule of law is a core value, as are the values of equality and human dignity. Now, what the current jurisprudence has developed is this: the rule of law includes human rights. And so there's a distinction between rule by law and rule of law. Remember, chattel slavery, abolished in 1834 in our regions, was legal. Apartheid was legal. Rule by law. So the nuance here, and it's important, is that rule of law includes human right values. And the last principle is this: judges, judicial officers are guardians of constitutional values. What does that mean? It means that we have the responsibility to ensure in every matter before us that the priority is the upholding of constitutional values, the upholding of the rule of law, and inherent in that, therefore, is the upholding of human rights. Now, that's a little bit abstract. Practically, let me just look at the time to try and see if I can get this done, and to let you know that there's a background paper that I prepared that is posted in the chat, and so don't worry if I'm not thorough enough. You can have a look at that, where these ideas are developed a little more extensively. There are 8 imperatives that I want to suggest that I'm going to go through with you this morning. Situational awareness, intersectionality, the use of non-punishment, the non-punishment principle, procedural fairness, avoiding secondary victimization, alignment with international law and practice, post-colonial approaches to the interpretation and development of the law, and mindful judging. Let me start with situational awareness and intersectionality and share with you the circumstances of a case. The fact scenario is actually very, very simple. It comes out of a 2013 decision of the UK Court of Appeal. A young person was prosecuted for the cultivation of cannabis. In the Caribbean, we say marijuana or ganja, but cannabis. Cultivation on a cannabis farm. When the matter reached the Court of Appeal, the Court of Appeal recognized that this person was the victim, and I prefer to say survivor, but the victim survivor of human trafficking, and as a consequence, quashed the conviction. So there was no doubt that this person was cultivating cannabis on a cannabis farm. That's an offense. Yet still the Court of Appeal quashed the conviction. Well, it's important because the Court of Appeal had situational awareness and recognized the intersectionality, how context and circumstance intersected with the charge that had been laid. How could they quash? What's the second principle I want to share with you? The non-punishment principle. Here's what the Court of Appeal said. The culpability of a victim of trafficking may be significantly diminished and in some cases effectively extinguished, not just because of age. Remember, this was a young person, but because no realistic alternative was available to the exploited victim but to comply with the dominant force of another individual or group of individuals. Simply put, this young person had no real choice, no real consent, no real agreement. That is the essence of being forced. And so this non-punishment principle, well known in international law, was applied. And it is something that we as judicial officers need to take into consideration. I just want to keep moving along because of time. Building upon the idea of situational awareness and intersectionality, we can move to procedural fairness. In essence, procedural fairness is a recognition, and that is not just in criminal matters, but in all matters, that court users experience and perceive court systems as fair when they have and are given voice. That is to say, they can participate meaningfully in proceedings, they are treated with respect. In understanding is important in that they are made to understand and time and care is taken to ensure that they understand why they are there and that they are understood, that they experience themselves in a context of trust where they feel safe and secure enough to trust and inclusivity. That is to say, they are made to experience themselves as part of a process seeking justice. But obviously, if these elements of procedural fairness are included in the work we do, we may discover facts not known or disclosed, maybe on the face of it unknowable, until we ask victims and survivors of contemporary forms of slavery, what has happened? Why are you here? Victim impact statements are another way, albeit when it comes to sentencing, that important information can be received by a court before, in the case of sentencing, decisions as to sentencing are made. Moving along, and again, this comes nicely out of the case of RNL, avoiding secondary victimization. This young person was already a victim of forced labor and of modern-day slavery. To then punish this person for cultivating cannabis would be a second form of victimization, a second layer of victimization. So by situational awareness, by procedural fairness, by intersectionality, judicial officers become aware and so have the information and therefore must be careful to avoid secondary victimization. Practically, in proceedings, try to put things in place to eliminate security risks. Remember, people may literally want to kill these victims who are these survivors who are now witnesses against perpetrators. We need to pay attention and manage psychological trauma and stress. Be aware that these contemporary forms of slavery, sexual exploitation, have a significant impact on mental health. And in a very, very practical sense, what kinds of questions are you going to permit? Questions about whether you consented to be in traffic, questions about sexual matters that may be irrelevant. Just be careful. Continue to move along, and I'll cover these last two very quickly in the interest of time. Modern approaches to law recognize that we exist in a global community. This is very true with modern forms of slavery because they are by definition, as Sneh told us, multifaceted and cross-border. And so understanding, we need to situate ourselves in the context of our roles as judicial officers in a global environment. How can we do that? Well, become aware of what are our state treaty obligations and see how those obligations, and Anne went through those with us in great detail, see how those obligations may impact the proceedings before us. Now, I know for those of us in the Commonwealth, we say we are dualists. Unless an international treaty is incorporated into domestic law, it is ineffective. Well, up to a point, because the modern jurisprudence, and it's in the background paper, our court is leading that in very significant ways, says, as far as is reasonable, try and interpret and apply the law aligned with these international values that our states have subscribed to. The last, well, second to last, the second to last approach I want to commend is what I call post-colonial approaches to the interpretation and the development of the law. Very, very simply put, we have to be very aware of what I call precedential limitations. That is to say, and that's what Professor McKerran was pointing us to, that the law that was developed and the cases that exist, for example, based on the 1926 Convention on Slavery, are contextualized by a notion of ownership. Well, ownership is a contractual term in the time of empire, which was a colonial time where the commodification, the objectification of people in a patriarchal, classist, racist culture, people thought of things in terms of contracts. It is interesting to note this, with the abolition of slavery, colonial powers paid compensation to who? To slave owners for the losses they incurred as a result of the dismantling of the slave trade. Isn't that interesting? But who were the victims and survivors? Hence the movement for reparations, but that's a different story for a different time. The point I'm trying to make is this: when we come to interpret the law, we have to do it in a developmental way. The supremacy of the Constitution, the centrality and paramountcy of fundamental rights provision tell us that we can interrogate colonial understandings of slavery and colonial interpretations of the law to suit our modern times. And the last little thing I want to share with you is what I call mindful judging. I'm not going to spend much time on that because I don't have much time, but what I am going to say is mindful judging is really the idea that you just need to be mindful. When you sit in a court, be aware of everything. Be aware of what's inside of you, what's outside of you. Be aware of what's happening in your courtroom. Why? Because when you are mindful in a 360-degree way, that kind of consciousness may allow you to see sometimes small things that you would otherwise have overlooked on account of familiarity. Maybe the way a victim survivor responds to a question that may give you a cue or a clue to go a little further. So I commend that approach. And finally, to end, a little story. It helps us understand the cultural question that was posted in the chat. The case of CHRI versus the Republic of Niger, the state of Niger. Well, Miss CHRI was 12, 1996, sold for a sum of money in the context of wahia, a practice obtained in the Republic of Niger. It was a practice which allowed usually an older male, known as a master in relation to the person, to enter into a contract which included conditions of servitude, both for domestic services and as a concubine. So for about 9 years, Ms. CHRI served in the house of her master, carrying out all sorts of duties, including serving as a concubine. She was sexually abused and the victim of violence over a long period of time. In 2005, she was issued a certificate of emancipation. That's what it's called, meaning you are now emancipated from this contract. But her master refused to allow her to leave. So she came to the courts. The ECOWAS Community Court had this to say, and I want to just share what they say with you as I end. Even with the provision of square meals, adequate clothing, and comfortable shelter, a slave remains a slave if they are illegally deprived of their freedom through force or constraint. All evidence of ill treatment may be erased, hunger may be forgotten, as well as beating and other acts of cruelty. But the acknowledged fact about slavery remains, that is to say, forced labor. There can be nothing like goodwill slavery. Even when tempered with humane treatment, involuntary servitude is still slavery. I commend that to you as I come to the close of this presentation. And I say that as judicial officers, we are called to action. I know there's much to think about, and I know there's much to be done. But guess what? We are the ones who are called to think and to do. I think we have the tools. Are we up to the task? Well, here's what. For thousands, now millions of innocent and vulnerable lives, for hundreds, if not thousands of communities and families, we, as judicial officers, are their only hope. Thank you for your time.
Thank you very much, Justice Jamadar. You stuck very close to the 15-minute allowance that we were given. Now, this means that we are going to have to miss our question and answer session orally, but we have received some questions in writing, and I have asked the panelists, as far as possible, to give written responses in the question and answer box. So I hope that this box will be open long enough for that to occur, as I am going to move towards the winding up of our session now. We had intended to address the question of what judicial training has already been implemented in the Commonwealth on this issue, and where it was implemented. And there is some good news that some Commonwealth countries, although very few, have systematic, recurrent, and ad hoc training for judges on issues related to modern slavery. And the countries that answered our survey and gave description of the programs that they have in place are England and Wales, the Bahamas, Belize, Canada, Cyprus, Botswana, India, Malaysia, the Maldives, Mauritius, Nigeria, Papua New Guinea, South Africa, and Tanzania. If any of your countries is working or wishes to work on these issues, the CJEI and CHRI, our two organizations who are hosting this webinar, stand ready to provide program support, including assistance in seeking financial support. And now I must proceed to thank our presenters for providing us with such an illuminating, even if sobering, description of the alarmingly widespread incidents of modern slavery and human trafficking. But they've also alerted us to the growing universal commitment for its elimination. We have learned that as judicial officers, we are challenged to identify and to prepare for the role that we can play in deterring and preventing its incidents by protecting victims and survivors and punishing perpetrators in our courts. I hope that our session has made you aware of the value that education can play in ensuring that all our judiciaries are prepared to combat this problem. As I mentioned, the hosts in this webinar are ready to support you should you require any assistance in developing and rolling out judicial education programs in this area. You have the contact information, which has been put in the chat and is otherwise circulated. I must now thank all of you who were sufficiently interested in this topic to join and share in the webinar. I trust that it has lived up to your expectations, and I hope that you are committed and ready to do your part in realizing the universal aspiration of the elimination of human slavery by 2030. I thank you all. Thank you very much. And I formally end our session, although we may remain online for a bit longer, to permit some responses to your questions in the question Q&A box and in the chat box. Thank you very much.